Appreciate all the members of the press and the other interested parties from coming out today. So I do have a statement to read about this matter, and then I'll be happy to try to take a few questions. Bear with me, it's a little long since the investigation was on. Okay, on or about December the 6th of 2015, at approximately 8:10 p.m., Mr. Michael Leinert of 1112 American Street, North Catasauqua, Pennsylvania, telephoned the non-emergency Lehigh County Communications Center to report that an, quote, injured cat, end of quote, was observed in his backyard. According to Mr. Leinert, the cat was in a sitting position, and it stayed in that position when Mr. Leinert approached it. According to Mr. Leinert, the cat appeared injured in the hind quarter area. According to Mr. Leinert, the cat moved very gingerly towards a grill that was in his backyard and stayed there in that position until a police officer arrived shortly thereafter. At approximately 8:10 p.m., Officer Leighton Purcell, an officer with the North Catasauqua Police Department, was dispatched and responded to the scene. The radio dispatcher specifically told Officer Purcell that there was a, quote, injured cat, end of quote, being reported in the backyard of the owner of 1112 American Street, North Catasauqua. When Officer Purcell arrived at the scene, he observed that the cat showed signs of mange, hair loss, and was bleeding from an injury on the cat's back area. Officer Purcell reported that the cat had a, quote, exaggerated limp, end of quote. Officer Purcell stated that the hind legs of the cat were not working properly and that it lumbered from the grill area over to the steps near Mr. Leinert's pool. The cat moved its front legs, but the back legs dragged abnormally. Both Mr. Leinert and Officer Purcell acknowledged that there was a blood trail. The trail started from the grill area in Mr. Leinert's backyard and continued over to the steps by the pool and up the next step where the cat had stopped. At this time, it was not known to the police officer or Mr. Leinert that a domestic cat was missing in the jurisdiction. The owner of the cat, Mr. Thomas Newhart, did not report that his cat, Sugar, was missing. At this time, Officer Purcell made a decision to, in his judgment, humanely end the cat's life and suffering. Officer Purcell fired a single shot from his department-issued .38 caliber revolver, instantly killing the cat. Thereafter, the cat was placed in a plastic bag for disposal. The investigation involving this matter was initiated after I received a letter from Attorney Jenna Flissar on or about December 21, 2015, requesting an investigation as to whether or not Officer Purcell's actions constituted a criminal offense under the Pennsylvania Crimes Code, specifically cruelty to animals. The matter was assigned to a Northampton County Detective, John Cassiano. Detective Cassiano, understanding the community-wide concern expressed about this incident, undertook a meticulous and detailed investigation. The investigation included, but was not limited to, interviews with Attorney Flissar, Officer Purcell, Chief of Police Kim Moyer of the North Catasauqua Police Department, Mr. Michael Leinert, Dr. Nathaniel Stanglang, the veterinary doctor who examined the cat at the request of the owner, Mr. Thomas Newhart, the owner of the cat, and Kathy Andrews, the Pennsylvania State Dog Warden. Detective Cassiano also obtained various documents, including the following. The letter from the Flissar Law Firm was part of our record. Officer Purcell's North Catasauqua's incident report, dated 12/6/15. The Lehigh County Communications 9/11 recording. The Stangline Veterinary Clinic Euthanasia Form. The Stangline Veterinary Clinic Medical Note Information Form. The Stangline Veterinary Clinic Medical Note signed by Dr. Stangline. A recorded interview with Dr. Stangline. Photographs of the cat and x-rays were obtained. 10 photographs of the scene were also done by Detective Cassiano. We also obtained North Catasauqua Police incident reports involving other matters involving the Newhart's loss of animals. The North Catasauqua Police Use of Force manual was obtained and reviewed. The North Catasauqua Borough Ordinance regarding animals was obtained and reviewed. We also looked at the annual positive animal report for rabies for November and December of 2015. I asked for Officer Purcell's personnel file. We also looked at two reports, which were an analysis of community needs regarding stray animal control in Northampton County that was dated August 29th of 2013, and a Humane Society Management Services stray animal report dated June 28, 2013. The investigation included listening to the 911 call made by Michael Leiner, reporting the injured cat, as well as the 911 dispatch call made to Officer Purcell informing him of an injured cat at the Leinert's residence. In addition, an extensive review of Pennsylvania law regarding the criminal statute of cruelty to animals was reviewed. Further, this office sought out additional information regarding the prevalence of stray cats and dogs in and about Northampton County, and I reviewed letters from concerned citizens from the Lehigh Valley and from other parts of the country regarding the actions and conduct of Officer Purcell. A review of the two studies conducted concerning stray animals in Northampton County provided useful background information to this investigation. In that regard, in 2013, Northampton County Executive John Stoffa had addressed the increasing problem of stray animals in Northampton County and commissioned the Analysis of a Community Needs report. Section 1 of the report, which was prepared by David Wolgum, Associate Director for Public Service at Lafayette, noted that Pennsylvania and its municipalities do not legislatively regulate cats, which means that police officers, animal control officers, and dog wardens are not picking up stray cats despite their large population. In fact, most states do not regulate the control of stray cats. Although there are no statistics that track stray cats, municipal officials and shelter managers all agreed that there are more stray cats in the public than there are stray dogs. The Pennsylvania SPCA Organizational Shelter Animal Report also revealed that there were 707 stray cats documented in the year 2014 in the county, while only 288 stray dogs. The report commissioned by Mr. Stoffa stated that the ratio in Northampton County was as high as 4-1 in favor of stray cats. Stray cats are a community problem. Stray cats also include feral cats, which are, according to the definition, an animal that does not appear friendly when approached by humans. The aforesaid studies concluded that there was no simple or all-inclusive solution to the challenge of collecting stray dogs or cats in Northampton County. I also wanted to speak to Kathy Andrews, who is now the Pennsylvania State Dog Warden and who worked in Northampton County for many years involving cases of animal cruelty. Ms. Andrews stated that currently Northampton County does not provide any services for injured or sick animals. Ms. Andrews related in an interview on February 10, 2016, and again with me on April 25, 2016, that most police departments in Northampton County and other counties throughout the Commonwealth have no provisions to deal with sick, injured, or stray cats. Essentially, she said, no one will take them. This office takes very seriously animal abuse, and my office has prosecuted cases of animal cruelty to animals a number of times over the years, and we have a number of pending cases at the present time. The cruelty to animal statute was designed to assure and protect animals, particularly domestic cats and dogs, and this office recognizes that Sugar, as a domestic cat, was a member of a protected class under the statute. Based upon the investigation done by Detective Cassiano and based on my review of all the information stated, I have determined that the following facts are relevant in this matter. One, that on December 6, 2015 at around 8:10, Mr. Leiner did report that there was an injured cat in his backyard. Number two, Mr. Leiner and Officer Purcell both agree on the following. The cat did not have a collar on which would identify it as a domestic cat rather than a feral or stray cat. Two, the cat had injuries on her hind quarters. Three, the cat initially did not move and when it did move, it walked gingerly, dragging its back legs and leaving a trail of blood. When approached by Mr. Leiner, the cat hissed and clawed at him. There was blood in the area of the hind quarters of the cat. The cat was clearly injured. The cat was limping. These facts are not in dispute and are agreed to by both the officer and Mr. Leiner. The injuries to the cat as described by Mr. Leiner, as I said, were also observed by the officer. Number 4 fact. There was also a concern in 2015 in December of reported rabies. Chief Moyer of the North Catasauqua Police Department stated that 2 weeks prior to this incident, 2 cats were known to have rabies. Kathy Andrews, Pennsylvania State Dog Warden, provided to me the annual positive report for rabies for the month of November and December of 2015, which documents that for November, Northampton County had 5 cases of rabies, and in December had 7 cases of rabies. Number 5 fact. North Catasauqua does not have an animal control officer. Number 6, North Catasauqua, although having a kennel for dogs, does not have a place for cats and does not take cats. I took a look at the North Catasauqua Police Department use of force policy, which reads as follows, and I'm going to read it verbatim, that a police officer may discharge his firearm under the following circumstances. Quote, to destroy an animal that represents a threat to public safety or as a humanitarian measure when the animal is seriously injured. End of quote. At the time of this incident, Officer Purcell had no knowledge whatsoever that the cat located in Mr. Leinert's yard was a cat owned by a citizen, since Mr. Newhart had not contacted the police. Believing in his judgment that the cat was seriously injured and with nowhere to take the cat, Officer Purcell used his firearm to end the life of Sugar. Subsequently, on December 8, 2015, 2 days later, the owner of the cat, Mr. Newhart, learned that his cat may have been shot. He retrieved it from the police department and took the deceased cat to the Stangline Veterinary Clinic. He brought Sugar to the clinic and completed the Stangline Veterinary Clinic euthanasia form to authorize the clinic to cremate the animal. When he filled out the form, he indicated that the animal had been hit by a car and died at home. This information was false. At the time that Mr. Newhart gave this information to the clinic, he knew that in fact his cat had died from a gunshot wound inflicted by a police officer. It is not clear to me why Mr. Newhart gave this inaccurate and false information to the clinic on December 8th. 2 days later, on December 10th, Mr. Newhart contacted Stangline Veterinary Clinic to inquire if Sugar had been sent out for cremation yet. Newhart requested that Sugar not be cremated, in that he now wanted the vet to perform an x-ray of Sugar to see if she had in fact a bullet in her, although he had been told that when he picked up the cat. The veterinarian staff later contacted the Pet Memorial Service and returned the body of Sugar. Sugar was later returned to the clinic in a frozen state. On December 14, 2015, Dr. Nathaniel Stangline performed a limited post-mortem examination and x-ray on Sugar. In an interview with Detective Cassiano on January 8th, Dr. Stangline said he could not perform a full necropsy on Sugar. A full necropsy is typically performed right after death, before rigor mortis and the freezing process. At the time of his examination, Sugar had been frozen for 5 days, and full necropsy was not possible. Dr. Stangline's examination was therefore a very limited on-site examination of the cat. No tissue samples or toxicology was performed. This was a general examination of the cat, which according to the doctor lasted between 10 and 15 minutes. No rabies test was performed. Sugar had all 4 claws and was not declawed. Dr. Stangline said that it was difficult to determine if the cat had been previously injured or sick from this examination. According to Dr. Stangline, his clinic had never treated Sugar in the past, thus knowing very little about this cat. Mr. Newhart is a client of Stangline Veterinary for his other pets, but he had not been brought Sugar there. Dr. Stangline further stated the following. 1. There were no rib fractures or pelvic fractures commonly found with a vehicle injury, whether the cat may have been struck by a car or not. No test for rabies was done because there was no report of a human bite or scratch. No bruising on the cat's body was located. It did not appear that the cat was bitten by a dog or another animal. There could be found no trauma to the back area of the cat, according to Dr. Stangline. Mr. Leinert told us that he did not believe that Officer Purcell acted with a malintent. The Pennsylvania Cruelty to Animal statute is found in the Crimes Code section 5511. The statute contemplates criminal liability with respect to the killing of a protected animal if the killing is done, quote, maliciously, end of quote. That is, with a bad state of mind, evidencing a social disregard for life or a meanness or a wickedness of spirit. When someone acts with malice or maliciously, the law impugns a bad state of mind, and the crime can be a misdemeanor of the first or second degree. The law of Pennsylvania in this regard is absolutely clear and provides the following points. In order to sustain a conviction for cruelty to animals, it must appear that the defendant acted with a cruel and done recklessly without regard for consequence. A defendant will not be found guilty of cruelty where there was a lack of cruel wantonness or malevolent conduct on the part of the defendant. The Commonwealth must prove that a killing is done with malice in order to support a conviction for cruelty to animals. Wanton in the context of animal cruelty statute means maliciously risking harm while being utterly indifferent to the consequences. In reviewing this matter along with the aforesaid information, I also took into consideration Officer Purcell's history. Officer Purcell graduated from Northampton Community College with an associate's degree in criminal justice. He later received his bachelor's degree in criminal justice from Lock Haven and graduated from the Police Academy in 2014. He serves as a member of the Pennsylvania National Guard. Past employers have given him positive remarks as to being prompt, performs his job well, and is a solid worker known for being reliable, honest, and hardworking. Taking all of this into consideration, I do not find that Officer Purcell acted with malice or maliciously. It should be noted that Mr. Leinert also said that he did not believe that Officer Purcell acted with malintent. The law does allow a police officer may shoot with a firearm and kill any animal based on a judgment that the animal may be injured, disabled, diseased, past recovery, or unfit for any useful purpose. However, that statute, which is Section 3 PS Section 325, which again gives the police officer the right to kill an animal based on the judgment that it may be injured or unfit for a useful purpose or diseased, the statute states that this must be combined with the written certificate of two reputable citizens called to view such animal or animals in his presence. In this particular case, Mr. Leinert stated to us that in his opinion, the cat, while injured, was not seriously injured. That was his judgment. Further, the North Catasauqua Police Department manual recognizes the ability to discharge a firearm only when confronted with a, quote, seriously injured, end of quote, animal. The necropsy, limited necropsy done by Dr. Stanline could not confirm that in fact Sugar was, quote, seriously injured. Therefore, this office is left with a dilemma in that although I find Officer Purcell did not act with a malicious intent in light of the circumstances, I cannot conclude that the protected animal should have been summarily killed without more of an effort to perhaps isolate the animal and perhaps obtain veterinary care. If the law allows any person, whether a private citizen or a police officer, to make a judgment that a cat or a dog that appears in someone's backyard is injured and kills it, it would give a license to any individual to shoot and kill animals under such circumstances. I do not believe that that is what the law contemplates. Therefore, under the circumstances that Officer Purcell faced, which was a visibly injured cat dragging its legs, knowing that there's no place to take it, and that's what was pretty much confirmed, with the idea that this was probably a feral stray cat, not knowing it was a domestic cat of someone, I felt that he did not act with malice. However, I did authorize Detective Cassiano to cite Officer Purcell under the subsection C of the Cruelty to Animals Act, which states as follows, 185511C, provides as follows: a person commits an offense if he neglects any animal as to which he has a duty of care, whether belonging to himself or otherwise, or deprives any animal of necessary veterinary care. This subsection of the Cruelty to Animals statute is a summary offense under Pennsylvania law. The issuance of a citation rather than the filing of a criminal complaint for a misdemeanor first or second degree, in my opinion, is reasonable under the circumstances. It takes into consideration all of the surrounding circumstances of this unfortunate matter. Lastly, let me make a number of additional observations regarding this case. The owner of the cat, Mr. Thomas Newhart, also bears some responsibility with respect to this matter and this tragedy. On 3 prior occasions, Mr. Newhart had allowed his animals that he was entrusted with to escape his premises and roam into the public area in violation of municipal ordinances. The following events are relevant. 1. On April 25, 2012, a man in North Catasauqua found a small beige-colored poodle running around his yard. The dog had no collar or tags. It turned out to be Mr. Newhart's. Mr. Newhart, and I have the reports, was advised by police to keep a collar and tags on his pets. 2 years later, on October 15, 2014, Mr. Newhart reported that Sugar was missing. Sugar had escaped. He contacted police and asked if the cat was found, if he returned to him. The cat was found and it was returned to him. Again, no tags or collars. On September 22, 2015, a young woman came home from school and found a small brown male poodle in her yard. She called the police, and the police took the dog to the kennel pending the location of the owner. The owner was Mr. Newhart. Had Mr. Newhart learned from his prior experiences, he could have had a collar or some identifying information on Sugar, which would have alerted Mr. Leinert and the police officer that this was a domestic cat and not a stray cat, one of the many roaming Northampton County. His neglect created a situation which helped lead to the tragic events in December. Lastly, the letter that was authored by Attorney Flissart to the North Catasauqua Borough Council, dated December 25th, 2015, and was copied to me and Chief Moyer, made its way into the public domain somehow, and contained numerous inaccurate factual information, which made its way into the press and created a mob mentality with respect to the actions of the police officer. For example, her letter indicated that the cat did not appear to be injured in any way. That was incorrect. Both Mr. Leinert and Officer Purcell and the investigation documented the blood trail and the fact that this cat was injured. The letter from the attorney also indicated that the law does not allow for a, quote, injured animal exception, which was also inaccurate. The law does allow for an injured animal exception for a police officer to, in fact, use a firearm to kill an animal, but it has to be done when the judgment of the police officer is combined with the certificate of two citizens who agree that the animal is disabled to that extent. The letter also indicated that Mr. Leinert had stated that the cat did not appear injured, which was inaccurate and not consistent with his recorded statement, which I listened to, and that he gave to Detective Cassiano. This misinformation led to thousands of people to form opinions based on inaccurate information. It unnecessarily enraged the public and helped actually to delay the investigation, because we had to try to run down this information and compare it and go back again and speak to people to make sure that we were not missing something with respect to the information that had been detailed in the letter. Now, I believe that this is a tragic case, and that all animal lovers, including myself, when I owned a cat and a number of dogs, want to agree that animals need to be protected. However, in this particular case, I do not find the officer acted maliciously. I believe that he made a judgment call, which many folks may not agree with, and I think perhaps the officer could have extended other efforts to capture the cat and get it to some vet, or at least to assess it before the cat's life was terminated. And that's why I believe that the reasonable approach to this case is to find no malice on the part of the officer, which I find, but to charge the summary citation, which basically indicates